Thank you very much for being with us here today. This is our Small Business Solutions Workshop at the Hillsboro Chamber of Commerce. I'm Deanna Paul. We have with us two folks that are going to be talking about one of the very hot topics during all of this COVID is employment, employees, employment laws, things that you need to be thinking about as an employer if you're bringing employees back. Things that you should be thinking about if you're communicating with your employees, talking about practices and handbooks, all of those things. Kelly, I'm going to turn it over to you to introduce yourself as well as Chris.
Thanks so much, Leah, and I appreciate the introduction too. So today what we're going to talk about is employment law, hot topics, best practices and considerations during COVID-19. And so if you're hoping to go to a seminar about something other than that, this is probably the right time to close out. It should be really interesting, kind of the topics that we're going to discuss today too. And today we're joined with Chris Morgan, and he's really an expert in the defense of these kind of complex and high-profile employment matters, representing employers. Well, I assume throughout Oregon. Do you do anything in Washington, Chris?
We do a little bit, yeah. Our office represents employers in Oregon, Washington, and California.
So yeah, the West Coast states.
Mm-hmm.
For hobbies, he enjoys golfing, spending some time with his friends, family, and running. And I'm an attorney at AssuredPartners, which is a commercial insurance brokerage. And in that role, I really specialize in designing risk management plans for companies in Oregon, Washington, Idaho, and Montana. Just making sure that they're covered. And you know, when I'm not working, I love to hike and I tend to read more than I should, but that tends to be a big hobby of mine as well. And so with that, we'll get right to it. Just to give you guys an agenda for our session today, we're going to have a survey of some employment law hot topics, which Chris is going to lead. And then I'm going to speak about some really just important, quick and dirty insurance issues to consider during COVID-19. And then we're going to have a question and answer session with kind of some of these issues. But of course, you know, to the extent we can, we'd love to have this interactive. So if you have any questions at any time, feel free to chat in the chat box. Of course, you know, if Chris is talking, you know, I'll kind of monitor that chat box and ask him the questions. And I would imagine he'd probably do the same favor for me as well while I'm talking a little bit. But we'll also have a formal question and answer session too, where hopefully we'll get some of your more specific issues addressed. And with that, we'll start with Chris. I mean, I can move the PowerPoint. There we go.
All right, good morning, everyone. Thank you for the introduction, Kelly. I'm happy to be here with you all to talk a little bit about sort of the current climate that we're in and some employment law considerations. It would take hours and hours and hours to go through anything and everything that employers should be thinking about right now with respect to COVID-19 and some of the safety, sanitation procedures that we should be thinking about. But what I wanted to do is sort of give you a high-level overview of some of the issues that we're seeing, some of the best practices that we've developed at Barran Liebman in terms of compliance standards, and just general best practices. So as Kelly mentioned, we're going to have a question and answer session at the end, but to the extent that you have questions on a topic that I'm speaking on, feel free to sort of chime in and we'll try and take questions as we go as well. But I wanted to talk initially about what I believe is probably the most important starting baseline requirement for any business. And this doesn't matter whether you're sort of a 1, 2, or 3 person mom and pop shop or you're a Fortune 500 company. The considerations, albeit different in the way that they're implemented and different in practice, are really the same. And that baseline consideration is that to the extent that our doors are reopened, we really need to have a comprehensive safety and sanitation compliance plan in place. And what that looks like is, again, going to be different depending on the size of your business, the nature of the business, and what it is that you do, and of course, any industry-specific standards that might be applicable to your organization. But I wanted to give you some sort of tips and best practices, some things that we're advising employers to do and to implement at their workplaces. So first of all, the safety and sanitation compliance plan should be in writing. And the reason it should be in writing is if an OSHA inspector comes to your door, well, one, let me back up. The first reason it should be in writing is because you should be critically thinking about it and considering different safety considerations within your physical workspace. And the best way to do that and sort of codify all that in one place is to write it down. But two, from a legal compliance standpoint, we want to have these things all organized and together in a single place so that if someone from the state, someone from the Occupational Safety and Health Administration comes and wants to check out what we're doing, that we can say, hey, look, we have a plan in place that's tailored to our business. And it shows that not only are we in compliance with whatever industry specific or baseline standards might apply to us, but it also goes above and beyond to the extent possible. So these things include just sort of basic things like having masks available to the extent that you have people coming into your business. Masks are required in indoor public spaces or places of public accommodation. That you have masks available for folks that otherwise don't have them. That you have things like hand sanitizer available for folks at different touch points, whether they come in and you have that available as soon as they walk in, or you have it available sort of as soon as they're to interact with a person. Those are things that you should be thinking about. And again, this is industry specific, and what works for one organization is going to be different than what works for somebody else. The key is that you have a plan in place that can corroborate the fact that you're thinking about these things, you care about the health and safety of your employees, and you care about the health and safety of your customers to the extent that you have them on the physical premises. So I understand that there's plenty of businesses where you're not actually interacting with customers coming into, your store any and every single day. There may be office spaces where you don't have visitors at all, except for maybe the mail person. One thing that we're recommending though, even to the extent that you only have your own staff on site as opposed to visitors, is that you have some sort of sign-in certification. So what we do, for example, at our office is every time I get off the elevators at Barran Liebman to go in, we have a booth essentially that's set up that has a sign-in sheet. It has a thermometer there where you can take your own temperature. And essentially you have to attest that your temperature is 100.3 degrees or lower. You also have to certify on the form that you're not experiencing any symptoms of COVID-19, such as fever, chills, nausea, etc. And what's going to be interesting about that is that the breadth of the symptoms seems to be constantly changing and expanding. And so, one thing that we're sort of trying to track is whether or not we need to be recommending that people expand the list of symptoms on their sign-in certifications and those sorts of things. But essentially the idea, right, is that to the extent that people are coming into your office space, you have a certification from them saying, hey, I've either just now taken my temperature, taken it in the last 45 minutes, and it's at below 100.3 degrees. I'm not experiencing symptoms. I haven't currently been close to my knowledge to someone who has been diagnosed with COVID-19, etc. What you want to do then is maintain that record for contact tracing purposes. And so essentially what you would want to do is have an office manager every day or the next morning scan in those sign-in sheets so that you have a definitive record of who was in your space at any given time. This serves two purposes. The first purpose, of course, being that we're monitoring who's coming in and out and making sure that we're mitigating safety risks to the extent possible. But two, we also have a record available in the event that someone does test positive or there is some sort of outbreak in our building or our office space, that we can let the state know, hey, here are records of who was in our space at any given time. So having this safety and sanitation plan in place is going to be key. Again, basic things like masks, sanitation spray, additional cleaning to the extent possible. And then sort of you have the option to go above and beyond. It's certainly not required, but I would definitely recommend some sort of sign-in certification where people are attesting, particularly for liability purposes too, that they're not coming in to your physical office space with a diagnosis that they know of, a positive diagnosis, or that they otherwise have symptoms. The next topic I wanted to talk about.
Yeah, one question on that, though,
Yep.
Fred, for the benefit of myself, but also maybe some of the attendees too. If I'm a small business and I think, okay, that's a great idea for me to have this plan. The only issue is, I might not be able to afford your hourly rate. Is there somewhere that I might be able to go to where I can get kind of a sample plan that I might be able to work from and tailor to my organization just for OSHA purposes or to mitigate my liability?
Yeah, so I'm not sure what all is online in terms of a safety and sanitation template. I can tell you though that on our Barran Liebman website, we have a COVID-19 specific page that is easily accessible at barran.com. It's just www.barran.com. We have a coronavirus resource page that is updated almost constantly with any and every topic that you could imagine related to sanitation, FFCRA compliance, which we're going to talk about, layoff considerations, telework arrangements, paid sick leave, all those sorts of things. And so if you're looking for sort of a place where there are comprehensive free resources that you can access, you may also be able to access those things through our website. Also, if you happen to be insured through SAFE, I know that SAFE has some really good resources on their website as well, specific to safety and sanitation compliance and those sorts of things. So digging around on the internet, going to our website, you should be able to find some good stuff. But again, I think if you're a smaller shop that doesn't have a number of people that you're worried about coming in and out, the key is just to have a basic plan in place that speaks to sort of the fact that you're implementing these safety and sanitation procedures. It doesn't have to be crazy complicated. It can be simple and straightforward. It can be a page.
Great, thanks.
Yep. So next I wanted to talk about the Families First Coronavirus Response Act and its interaction with the ADA, the Oregon Family Leave Act, and then FEMLA, which is the Federal Family Medical Leave Act. And I wanted to spend the bulk of our brief time on the FFCRA just talking about who's eligible and the circumstances under which someone would otherwise be entitled to leave under the FFCRA. So the FFCRA was part of the federal legislation that essentially did a couple of different things. It provided paid sick leave for certain circumstances. There's 6 different circumstances that are specifically related to COVID-19. And it also expanded the qualifying reasons for taking FEMLA leave, which is the Family Medical Leave Act. So under FEMLA, it's an expanded reason, a qualifying reason to be able to take leave now if you are unable to work as a result of needing to care for a child in that child's child care center or facility that you would normally take them to is closed. I would really, in all practicality, expand it to if you are unable to work as a result of not having childcare available to you, it is likely a reason, a qualifying reason to be able to take leave under the Family Medical Leave Act. And employees typically are eligible just as they normally are. If there's a FEMLA qualifying employer and you are a FEMLA qualifying employee, which simply means that you have a qualifying reason to take leave, you're typically entitled to up to 12 weeks of leave in a given calendar year for that purpose. But what the FFCRA also does is provide paid leave for certain circumstances related to COVID-19. And to be able to take this leave, you have to, and this is really the threshold piece of this that we're seeing issues with, and I'll tell you why here in a minute. But what you need to be thinking about right away, if an employee comes to you and says, hey, I can't work because I need to quarantine. So the two sort of most prevalent reasons of the 6 for taking leave under the paid sick leave provisions of FFCRA is that a medical provider has recommended or required you to quarantine as a result of some COVID-19 related circumstance, or you are seeking a medical diagnosis for some reason associated with COVID-19. Now, what we're seeing is people saying, hey, I was at a restaurant or I was at a department store, whatever, where I found out that someone tested, positive. I'm now going to self-quarantine. A self-diagnosis or a self-imposed quarantine is not necessarily going to be a qualifying reason for leave under the express language of the FFCRA. And so there's plenty of people that are saying, hey, I need to self-quarantine. And irrespective of whether they're right or they're wrong, the inquiry you really need to be looking at for purposes of the FFCRA and entitlement to paid sick leave under those provisions are whether or not a medical provider has told that person that they need to quarantine. On the Barran Liebman website, and again, a lot of this is dense and I'm sort of just giving you the overview, but if you want to dive into the requirements and sort of a nice summary of paid leave entitlement under the FFCRA, if you go to our website, we have on that COVID-19 resources page a handful of articles on the FFCRA. If you go to my webpage specifically at just my normal page on our Barran Liebman website and go to my publications, I have an article that I wrote on the FFCRA, the amount of pay that needs to be provided and that sort of thing. And that's going to be a good resource for you to sort of be able to say, okay, to the extent I have an employee saying, I want to take paid leave, are they, and you can pull up my article, right? Are they meeting the requirements that Chris is saying they need to meet in order to be eligible for paid sick leave? And the reason this distinction is extremely important is because we're required as employers to provide paid leave in these circumstances where, otherwise under OFLA, FEMLA, the ADA, those sorts of things, to the extent that we're requiring or providing leave as an accommodation, that typically is unpaid unless someone wants to use any accrued but unused paid time off to cover that time. What the federal law is saying now is to the extent that they qualify under the FFCRA, we have to pay them. Now, under the paid sick leave provisions of the FFCRA, they're only entitled to 2 weeks or 80 hours total of pay. And under the expansion of FEMLA for childcare reasons, they're only entitled to a portion of their pay for a certain period of time. But it is complicated, and at the end of the day, and we've yet to see exactly how this is going to shake out, employers are supposed to be able to get a payroll tax credit back for any money that they shelled out to pay for time that qualifies under FFCRA. And it's supposed to be 100% credit, right? So to the extent that I'm paying under the FFCRA, we want to encourage people to give that paid time off because we want people to be able to quarantine. We don't want them to feel forced to come to work. We're going to be able to get that money back essentially via a payroll tax credit. Now, in all practicality, how is that going to work out? It's sort of like the PPP loan, right? Everyone's sort of trying to navigate how much of this are we really actually going to be able to recover in the end. But it's important to the extent that you're providing leave under the FFCRA, that you're designating it correctly, you're going through a proper process for understanding and designating whether or not it's actually leave that qualifies under the FFCRA, or whether you're saying, hey, I'm just gonna let this person stay home and self-quarantine, even though a medical provider has not told them that they need to, because they can otherwise work from home and it doesn't matter. We'll talk about some complications with teleworking here in a minute. And I'm going to talk a little bit more about the ADA, OFLA, FEMLA at the bottom here with respect to accommodation and best practices. But wanted to touch briefly on layoffs, rehires, and final paychecks. And there's a couple of highlights on those that I wanted to note, because the unfortunate reality is that a lot of employers have had to make difficult decisions about either temporarily or permanently laying people off over the last several months. A lot of employers have been able to bring folks back already. Some haven't, some are waiting. It's sort of, it's again, one of those things that really is dependent on this individual inquiry of whether or not it makes financial sense for us to reopen, whether or not we're able to even comply with the industry specific guidelines as they're written now, et cetera. But a couple of notes and best practices I wanted to give you on layoffs and terminations, to the extent that these are things that you have to do. The most sort of common, at least in my experience, pitfall with any termination decision, any separation of employment decision, is ensuring that final paychecks are paid out in a timely manner. Oregon has very strict laws and regulations depending upon the day of the week even, and it breaks it down to the day of the week, whether it's a weekday, whether it's a weekend, etc., that the termination was done, or the separation and termination, of when that final paycheck needs to get into that former employee's hands. And that, of course, needs to include any accrued but unpaid time to date. It also needs to include the payment of any benefits that they would otherwise be entitled to. So, for example, if I have a company policy that says that upon separation, I'm going to pay out half of any accrued but unused paid time off, we want to make sure that the money that accounts for half of that accrued paid time off is also included in that final paycheck. Now, as a side note that some people sort of get confused about sometimes, PTO and the payout of PTO is a matter of discretion for each individual employer, right? Employers do not have to pay out paid time, vacation time upon termination unless they otherwise promise that they will. So these things show up in handbooks all the time, right? We have, if you have a policy that people are going to get 2 weeks of vacation every year, you can roll up to a week of vacation, and then at the point of separation, we're going to pay out all of that or half of that or none of it. It's up to your discretion, but the key is that you're following your own internal policy with respect to whether or not you're going to pay those things out or not. Separate from that, and here's where it gets a little bit complicated, because some people have policies that combine leave that's accrued under Oregon sick time and leave that's independently accrued under a vacation policy, for example. Oregon sick time, there's no requirement to pay out Oregon sick time upon termination. However, if you are reinstating or rehiring the employee within 180 days of when that termination or layoff occurred, you have a statutory duty to reinstate that paid sick leave balance. So practically speaking, say that you laid someone off 2 months ago, you're opening again in 2 weeks and you're hiring them back. You have a statutory duty to reinstate any time that was available and accrued under Oregon sick time only. You have a duty to reinstate that leave balance. Now, if you decided to pay that out, even though you didn't have to, upon the layoff, you don't have to reinstate it. But to the extent that you didn't pay it and there was time that was accrued and unused, you have to reinstate that balance now. If you had paid it, they just start over accruing time pursuant to your normal policies. But the reason that it's important to sort of get some of these exit things correct are because we want to avoid a final paycheck claim, right? And these are super common employment-related claims where someone says, hey, thanks for getting me my final paycheck a week after you fired me. One, it was late under statute. You didn't get it to me on time. 2, it didn't include all the wages I think I'm owed. 3, it didn't include a payout of the PTO that I was entitled to under our policy. So therefore, I'm giving you 2 weeks to pay me or I'm going to sue you. Company says, nope, we paid you everything we thought we owed you. And then all of a sudden you get sued for final paycheck violations, which not only could you potentially owe whatever you didn't pay out, but there's penalty wages, there's liquidated damages under the Fair Labor Standards Act, and employees in Oregon are entitled to the entirety of their attorney's fees in these wage claims. So for example, an employee might go through trial and the jury says, hey, yeah, you know what, your employer did short you by $1,000. And we do think that you're owed $1,000 and then another $1,000 in penalty wages or whatever. But their attorney has also accrued, $110,000 in fees litigating that case. You're also on the hook for the attorney's fees. So they may say, you're owed these wages, but you're also on the hook for the attorney's fees, which are a much, much larger portion. My job is to help you avoid that happening. And so it's really, really important to get these final paycheck issues correct so that you avoid a wage claim that carries with it plaintiff's side attorney's fees. And with a lot of the turnover and rehiring that's going on right now, it's more important than ever to be paying attention to those things. One other thing I wanted to note in terms of rehiring is typically when you hire someone, you have to fill out a Form I-9, a federal form, which is an employment authorization form. To the extent that you are rehiring someone who has filled out a Form I-9 within the last 3 years, you do not need to go back through the process of filling out an entirely new Form I-9 for that person. So say I hired someone 2 years ago, filled out the Form I-9, had to lay them off a month ago. Now I'm bringing them back on tomorrow. I do not need to fill out an all new employment authorization form for that person. All I need to do is go back into Section 3 of the Form I-9, which includes some lines and boxes for rehire, and put in their date of rehire, sign, and date it. But a lot of employers have sort of been spinning their wheels, going back and redoing all of this employment authorization stuff and getting passports, and makes the re-onboarding process significantly more cumbersome. You don't need to do that necessarily. So think about that. This final paycheck stuff, this Form I-9 stuff, again, articles on all of these different topics on our website that you can sort of take a look at and browse, and it's all free.
I have are you finished with that kind
Yep.
of topic there?
I
I
am.
have a question for you about that. So for the attendees, Chris and I spoke a little bit about retaliation claims with COVID, and I'll just summarize it really quickly here. Basically, what Chris is seeing is occasionally an employee will complain for an unsafe work environment, and then after that, they're discharged. Obviously, or generally speaking, the employer alleges that they were discharged for a reason other than complaining, and the employee alleges that they were discharged for complaining about the unsafe work environment. Is there a way, and unsafe meaning that there weren't proper COVID protections in place, people weren't wearing masks, something of that nature? If I was an employer, how would I lower that risk of getting those kind of lawsuits?
Mm-hmm. That's a great question.
With still firing them. I mean, I can keep them on forever, but that's not.
That's a great question for any employer, and this is more important than ever with the COVID situation going on. But as a general best practice, employers need to be, one, taking every complaint that they get about anything extremely seriously, documenting and following up on the complaint and putting all of that in writing. But two, to the extent that you're making any disciplinary decisions, and that includes terminations, of course, but if you're demoting someone, changing their hours or work schedule, really to the extent you're taking any adverse action against someone, documenting the reasons why you are taking that action. Because the way that these lawsuits play out is you say, hey, I'm laying this person off because they're the most, the least productive person on that particular team, right? And then that person comes back and says, no, the reason you actually laid me off is because I complained 2 weeks ago that I didn't think we had the proper safety and sanitation procedures in place to reopen the office. You reopened it anyways, and now all of a sudden you're firing me. How convenient. There's no avoiding that. Anytime that you take any adverse action against someone, there is always the risk that they can come up with some pretextual discriminatory reason for why you took that action. And then my job in that situation as a management side employment attorney is to prove to the court why you took that action on the basis of legitimate, objective business reasons as opposed to some discriminatory reason. And the biggest way that any business can help in that is to contemporaneously document the reasons why you're taking the action that you are. So saying, look, out of the last 6 quarters, this person has been the worst performer by far. Here are the numbers. We've had 3 different performance improvement plans that we put them on, in which, you know, we put them on notice of these issues, gave them a chance to improve. Also, we've had 3 independent complaints that this person is gossiping at work and creating what could be considered some sort of hostile work environment if we don't take action against it. To the extent that you can document all of these legitimate reasons for why you're taking the action that you are, that is the best way to mitigate risk. Because in that situation, it's much easier for me to point to these independent, legitimate reasons for why you took the action that you did and say, any notion that this was discriminatory or that this action was taken on the basis that this person raised COVID-related concerns is ridiculous. So documentation is key.
And then, of course, it depends what you're documenting too, I would imagine. And that you don't want to document, you know, a discriminatory reason.
I would hope they wouldn't, but.
Yeah. Is there, because a lot of employers, they have handbooks. And as you know, and this is probably incredibly frustrating for an employment attorney, but there tends to be a handbook as written that you guys write, and it's incredibly well written. And then there tends to be something that everybody does. And a lot of times, oftentimes they're not the same thing. When preparing for a discharge, what steps would you take?
Well, depending on what the reason is for the discharge, and again, this goes back to documentation that either you're going to end up putting in a termination notice or that's going to end up in a conversation that's had with whoever the employee is. To the extent that you can tie any adverse action that you're taking to a specific employment policy that's codified in your employee handbook, it's extremely helpful. So as a practical example, right, and this is becoming even more important as we head into the fall with Oregon's new Workplace Fairness Act provisions going into place, which essentially require companies to have a pretty comprehensive harassment and discrimination policy. To the extent I have a handbook that clearly outlines what my anti-harassment and anti-discrimination policy is, and I have that person, and I'm a personal big fan of getting signatures on everything. Most people in their employee handbooks have the employee sign at the very end. That's great. My huge preference is to have people sign on at the bottom of every single page. The reason being, a lot of people don't read handbooks, and at the very least, they're going to have to flip to the page and sign it. And it's easier for us on the back end to say, look, you saw the harassment policy. You read the harassment policy, didn't you? So if I'm taking adverse action against someone on the basis that they have been accused of harassment, we did an investigation and the complaints were corroborated, and we're firing that person because they're engaging in inappropriate sexually harassing behavior, I'm for sure going to tie that specifically to the harassment policy that was put in front of this person in the beginning of their employment. Say, hey, you're being fired because you understood, we were transparent with you about what the expectations were, and you failed to follow our harassment policy, and that's the reason we're taking adverse action against you. So it's important to have a good handbook, extremely important to have a good handbook.
Would you recommend that folks that that after this COVID, because obviously there's been a whole bunch of legislative changes because of COVID, that they have their handbook reviewed to ensure compliance with these updated statutes and case law?
Yeah, I really would. We're doing a lot of sort of going back right now and updating people's handbooks and making sure that they have all the new provisions that they need to have under the Oregon Workplace Fairness Act. In terms of, expediency and efficiency, oftentimes it's easier for us, for example, to provide a company with a new handbook as opposed to revising anything and everything that they've already done. Because odds are there's so much that has changed and this is constantly evolving that odds are your handbook is probably not updated and compliant. And that's no one's fault, it's just most employers' handbooks are not. And a lot of times it's easier for us to say, hey, we're gonna give you a new handbook that has everything in it that it needs to have, roll this out to employees, as opposed to going back and fixing anything and everything that you may have done in the past. But, handbooks are important, extremely important. And it's something that people need to have reviewed. If it's been a while, now is definitely the time.
Great, thanks.
Okay, so I'm going to run through these last two ones fairly quickly so we can get to sort of to you, Kelly, and to some Q&A at the end. So speaking of handbooks, telework arrangements, extremely important. Traditionally, most people, if they even have a telework or remote work policy, it's maybe a paragraph in their handbook. It's never a standalone document or something that we take particularly seriously. But obviously now telework has become sort of extremely prevalent. And to the extent that you have people working remotely consistently, it raises a number of issues depending on what kind of employer you are, how many people you have working remotely, et cetera. And it raises a number of issues. Is this person being productive? Odds are they may not be as productive as they otherwise would be in the office. It's just sort of human nature. What are different ways, right, that we can counteract that by measuring productivity or checking in with them more often? That's one consideration, right? How am I mitigating workers' comp risk by saying, hey, this is the general work environment that you're confined to, so that someone's not out on their break walking their dog and then files a workers' comp claim that's ultimately going to end up costing you more money. How do I ensure that non-exempt employees are taking breaks when they need to be taking breaks, right? So if I have someone who's an hourly employee that's working from home, my wage and hour obligations with respect to meal and rest break compliance are still the same as if they were in the office. So what I'm getting at here is you really should have, to the extent that you have people working remotely, an actual telework agreement that outlines the expectations with respect to productivity, that outlines the general work environment, where they're attesting that they're taking the breaks that they should be taking, et cetera. And again, we have, I think a recent article I did maybe 2 or 3 weeks ago. Again, if you just go to my page on our website, www.barran.com, I outline, I think, 4 or 5 key considerations for a comprehensive telework policy that'll give you a good guide of what should be in there. But I do think they're very important and something that are becoming an issue. And as you could also imagine, you have sort of the issue that comes up of, hey, I as the employer do not think that this employee can perform the essential functions of their job working from home. The employee says, oh yeah, I can do everything that I do in the office from here. How do you manage that sort of situation where I see things differently than that person? And so check out some of those resources we have. They're interesting sort of issues that people are navigating right Okay, accommodation best practices. I'll make this short here, but you need to be thinking hard. As soon as you get a request or any semblance of a request from an employee that they are not comfortable with the work environment, that they want to work from home, that they have concerns related to COVID, you need to be taking these things seriously, and you need to start documenting them right away, because whether they're right or they're wrong, accommodations under the ADA specifically require employers to interact with employees to try and find some reasonable accommodation that they might be entitled to. Now, specific to COVID, right, and under the ADA as well, someone would have to actually prove, right, that they have a qualifying disability under the ADA that limits one or more major life activities in order to be statutorily entitled to a reasonable accommodation. But as best practice advice, really what we should be doing in order to mitigate risk is saying, okay, irrespective of whether or not this person would be statutorily entitled to a reasonable accommodation under the circumstances, if they're raising concerns to me, are there adjustments that we can make to make that person feel more comfortable, right? If they want to work from home and they can work from home, ask yourself, why aren't we allowing that to happen? Because that's the way that we mitigate risk, right? We make people happy. Happy people don't sue people. People that ask their employers for help or guidance and feel disgruntled because they're turned down, those are the people that sue people. So the overarching idea here, right, is to the extent that we can mitigate risk through just being accommodating and being caring, showing folks that we care about them, that's what we should be doing. Whether or not we have a statutory duty to do that under the ADA or OFLA or FEMLA, that's the mindset that we should be approaching this with, is to be accommodating and to be as helpful as possible. So that's kind of what I wanted to leave you with. Again, there's tons and tons and tons that falls under this umbrella. I do encourage you to go to our website and just check out that free resources page where there's dozens and dozens of different articles and things like that. And to the extent that you're not signed up for Barran Liebman e-alerts, there's a place on the website to sign up for it. Essentially, anytime there's a new law that comes out or something you need to think about or something you need to update, our marketing team sends out an email to you. It's not spam or anything like that. There's items that are important that need to know, and they come right to your inbox, and it's all free. So,
hey, thanks, Chris, so much. Yeah. I'll go through this pretty fast. That way we can get to some questions if they exist. How does that sound, Deanna? Okay, thumbs up. Okay, so kind of what Chris talked about, or the employment, all the employment law type stuff. And so what I'm going to talk about a little bit is some insurance coverage issues that really you should be looking at and thinking about at this time. Obviously, oftentimes these insurance coverages, if you do get sued, may cover you. And so, that helps in that, it makes it so that you can pay somebody like Chris or somebody else. And also in the case that you're found liable, that way you're not having to pay for that yourself either. And so there's a couple of big issues that we're seeing. One of which is your first party insurance, first party property insurance. Oftentimes we're seeing our clients who are basically impacted adversely by COVID-19 are really trying to look for ways to recover. And generally, first property insurance is one of the big ways. There's interruption of business operations or of a supplier's operations is generally covered with this. What we're doing for our clients is we're kind of really helping them analyze it and really arguing or asserting what we can with the insurance carriers to argue for coverage. And but if you'd like to do this yourself, you can as well. Generally, what you should do is you should look through these policies and determine the policy breadth of the first party property insurance policy. This deals a lot with whether or not it's an all risk policy or a named perils policy. ascertain whether the coverage can be triggered by the losses in question. So generally speaking, COVID-19 losses, the insurance carriers are arguing they're not covered. Very, very rare exceptions are we seeing anything that the insurance carriers just say that it's covered. However, in Oregon, there's a very strong argument that these are that they should be covered claims, despite the insurance carrier's assertion to the contrary. In the case you'll see below that section, Oregon Shakespeare Festival Association versus Great American Insurance Company, and in that case, basically what happened is the Oregon Shakespeare Festival sued their insurance carrier for coverage, and they said that what we had smoke was a direct physical loss to our premises, and because of that, we should have coverage. And so under the same kind of analysis where, if smoke is a direct physical loss, then a virus could be a direct physical loss. And so that's definitely an argument there. And so even though it's most probably unlikely that the insurance carrier will cover the loss themselves, that there's definitely a strong argument that it should be covered. And so what we're recommending all our clients is that if you think that you have coverage, even if you think you don't have coverage, file a claim. You definitely should file a claim for any of these things. If there's one thing you get from this, it's file claims. And that way you're preserving your rights under your policy, and you can, kind of, in the event you want to, you can litigate that later. Another big issue here is cancellation in travel insurance coverages. If you have that, you definitely should review those coverages for any potential coverage in that respect. Obviously we're seeing a lot of communicable disease coverages there, and so that's definitely something you want to look through with your broker or yourself. And then directors and officers and commercial general liability coverage. This is a big one. So workers' comp, generally for those of you who may have a very small organization, workers' comp is basically what happened is in the beginning of the last century, employers and employees entered into an agreement where they said that basically if the employees get hurt on the job, there's going to be no fault and we're going to cover them for their injuries. And in exchange, the employers got rid of a lot of their liability through that. And then that's an insurance policy that employers buy for their employees. Generally, they're required to purchase it if they're a subject employer. Of course, there's tons of exceptions to whether or not you're a subject employer, but most employers tend to be subject employers in Oregon. If you want to, I'm happy to discuss that issue more with you for free, of course, later. But what's happening is we're seeing that if somebody gets sick on their job, is that a workers' comp claim? Can they file a claim under the workers' comp policy? And generally the answer, like everything, is it depends. And it depends whether or not they actually contracted COVID on their job. It tends to be very difficult to prove that they actually got COVID from their job as opposed to somewhere else. And so that tends to be a little bit of a difficulty there. But we're seeing in Oregon and in some other states that are thinking about enacting a presumption, saying that if you got COVID, it's presumed that it was from your employment. California enacted something to that extent. And of course, there's talk about Oregon implementing that legislative change as well. California, I think they mentioned that they think it's going to cost them, several billions of dollars in additional cost because of that presumption. And so folks that are interested in lowering their insurance premiums should probably be against that presumption, and folks that are interested in having coverage under workers' comp for COVID would be probably for that presumption there. Directors and officers policies, I think that's definitely somewhere to look for possible coverage. Commercial general liability, if somebody comes to your office and becomes sick, and they're not, your office is not taking all the precautions that Chris outlined, there may be some coverage there as well. And so it's very important to review all these policies really with an eye for the exclusions and seeing maybe this exclusion is not what we should have here, and talking with your broker about how to do that. Or better yet, hopefully your broker already contacted you about these issues, like we have with our clients. And then, so that's definitely something you want to look through. coverage and other protections available through all sorts of different contracts and indemnification provisions. So even if you don't have any of these policies, and it's just there's no way you have coverage, you definitely should look through all your contracts with all your suppliers to see if there's any indemnification provision, which for those of you who are not familiar with indemnification, it means basically that someone agrees to take on your risk. And so if you have that provision in your contract, that means that they are acting in effect like an insurance carrier, and that they're taking your risk for you. And so that's definitely something to review as well. With all this kind of stuff, if you have any questions, of course, we're going really fast, this kind of important material, I'm more than happy to, to talk to you for free about any of these issues, or review your policies and see what options might exist. And also, there's a lot of options here for decreasing costs as well. But for those of you who aren't interested in doing that, this is kind of the big steps that we're recommending for insurance claims. Number one is to provide prompt notice to your insurance carrier, and this is incredibly important. You really, if you think you have a loss, you should file a claim for that loss if it's a COVID-related loss. And then number two is you need to account for all your losses and damages. And just like Chris mentioned with discharge, it's more credible if you do it contemporaneously, as opposed to if you're going back in time and trying to imagine what your losses were. So while you're doing it, if you're sending, if you've got an email account, something of that nature that timestamps it when it happened, or even if it's not timestamped with an email where it's really credible, but even if you're just writing the date and time on a sheet, that's incredibly useful. If you do want to, you can work with an attorney or an accountant or something of that nature also to help account for your losses. And then the third step is what's really important is when communicating with the insurance carriers, you want to be, obviously your goal is to have coverage. And so you need to make sure that you're presenting to the insurance carrier in a way that, one, is completely truthful, and two, is not presented in an unfavorable manner for yourself. And so you really want to make sure that you're not stating something that, that you do not have any obligation to state, but that only serves to defeat your claim. And so those are two very important issues as well. And so, that's kind of what I do is I really try to help out folks present their losses to the insurance carrier in a way that increases the probability of recovery there. And then with that, I guess that's the end of the show here. What we'll do is, I think we've got, what do we have? We've got about 7 minutes. So we'll see if we have any questions here for Chris or myself. I know Chris touched on a whole bunch of stuff, and so if we don't have any questions, I've got a couple questions for him. But we'll feel free to use the chat box. I believe if you I guess what I do is I press more and chat, but I imagine it probably is a similar setup for you guys as well in the audience. If you have any questions there. But my first question for you, Chris, though, is with telework. You mentioned that sometimes an employer might, they don't want to force someone to go into the office. Oftentimes they can't do that. But they also are not totally trusting that their employees are working, to the grindstone 8 hours a day or whatever. What should an employer do in that situation?
So the strategy that I think, and again, it's different depending on the relationship that who that person reports to, how comfortable a supervisor is with checking in on someone with respect to productivity and workflow and those sorts of things. But what I would recommend doing is implementing more regular checkups on productivity. And there's nothing sort of that is preventing you from doing that. Although, we want to stay away from, hey, my employer put me under increased scrutiny because I'm working from home. So we want to word it correctly, right? We don't want to say, hey, you're screwing up, you're not working, this is why we're doing that. But you can certainly, put into place some additional measures for gauging productivity, saying, hey, as opposed to, checking in every 3 weeks on how things are going, and if you need anything from me, we're going to check in once a week just to ensure. You can even frame it, right, as saying, we all don't see each other anymore. So we're just going to be more connected and hop on, a Zoom call and talk about what you have in the pipeline, how things are going, etc. Right? There's a million different ways that you can do it, but the productivity thing is a real concern and something that's coming up quite a bit.
Yeah.
So you got to kind of address it sooner rather than later, because the longer, if you're having that issue, the longer it goes on, the easier it is for the employee to say, well, you didn't say anything the first 2 months that I wasn't doing anything. And then, I had a complaint and now you're saying we're going to check in 3 times a week, right? If it's an issue, I'd recommend jumping on it sooner rather than later.
Yeah, absolutely. Well, I know I've got another question on that with that regard too, because I was speaking with a friend of mine who will remain nameless. And, but I think like a lot of folks, they spend a lot of time in the office trying to look busy. Really, the productivity there is it's like there's 4 hours of productivity and 4 hours of looking busy.
Yeah.
And I noticed that you mentioned a lot, your focus was on productivity.
Mm-hmm.
Does that mean if I'm working from home and I only work 4 hours, but I'm doing the same productivity level as I could have done at the office, but it was just me being there so my boss could see me at the desk?
Mm-hmm.
Is that acceptable or is that not?
Well, it's different for everybody, right? Some people are more productive at home than they are in the office.
For sure.
Because they're not having to interact with other folks that are there, not feeling like they have to small talk in the break room. They can just sort of sit at home and get things done. A lot of other people are understandably having a lot of difficulties that aren't their fault working from home, juggling childcare and running a household and working all at the same time is extremely difficult, right? And so really with respect to productivity, it's going to be different for everyone. But if you are seeing issues with productivity, there are different ways to address it, but they, however you end up doing it, they are things that people need to address. And an issue that we're seeing more prevalently, right, is employers saying, hey, we've been work from home for, 12 weeks now. This person isn't working. They're not bringing in any business. Can we fire them? What do we do, right? So
yeah,
there's a million these things just come up, right? And who knows if we'll ever be back to sort of full work in the office anytime soon. So
yeah, well, I'm sure. And I guess, so when you're defining the word productivity, I guess what you're saying is a lot of it depends on how you define that term, whether or not it's, whether or not productivity means hours worked, or whether or not productivity means if you're a salesperson, clients gained, or if you're an attorney, maybe hours billed or something of that nature. Is that right?
Exactly. So whether you're measuring it as, things that are sold, I certainly don't tend to measure productivity. Well, I suppose as an attorney, it's a little bit different, but generally, I would say most employers do not necessarily measure productivity by hours worked for the exact reason that you brought up. There's scientific studies on how much work actually gets done relative to the amount of time that someone's in an office. I don't have any of the numbers in front of me, but
just out of curiosity, do you kind of remember what they were just vaguely?
I don't know. I want to say it's something like, 50 minutes to every, hour that you're sitting there. And then I think that number probably tends to decrease the longer that someone's there, right? So it may be 50 minutes sharp for every hour, the first hour you're in the office, and then it may sort of deteriorate as you get later into the afternoon. But there's definitely, and don't quote me on those numbers, but there are definitely some scientific studies out there that speak to productivity levels relative to different work environments, as well as time sort of physically spent in a chair doing work.
Yeah, of course. And that's one of the reasons they have, why it's a good idea to give people breaks as well.
Yeah, absolutely.
Well, I'm going to break in just for a second and see if any of our attendees have any questions. We're getting close to wrapping up, and I just want to make sure that we've answered anybody's questions. So feel free to unmute yourself, and if you could put your websites in the chat for everybody, that would be great.
Oh, sure.
Any questions from our attendees?
I have a quick question. Hi, my name's Dan Stark. I work for Epson. When we have some people working from home, so what is our responsibility then for supplying like a chair, a desk? I mean, everybody's given laptops that can work from home, but if they need a monitor, is that also fall back onto me for supplying all that?
Hey there. So that's a really good question. And I think it depends. It depends upon whether or not whatever piece of supplies is requested, whether or not one that's necessary for the person to perform the essential functions of their position, and two, whether or not that person actually, is in need of some sort of accommodation, if that makes sense. So some people now sort of house these ergonomic requests for certain materials under a disability request, right? They say, my back hurts and I need a standing desk. And then they might request, we've had people say, okay, well, to the extent you're gonna make me work from home, I now need one of these standing desks at my house, right? I think you need to evaluate each and every request for accommodation or request for supplies relative to the individual person, and to accommodate it to the extent that it's not an undue hardship, if that makes sense.
Yes, it does. Thank you.
Yep.
Right, final question. Anybody have a final burning question? Great information, by the way. Thank you so much. This was lots of information, but really, really timely and great. And I know it's stuff that folks are asking, all the time about, because these types of questions are coming up, and we do want to, obviously treat our employees right, but we also have businesses to run, and doing both of those things together sometimes creates a bit of conflict. All right, I don't see any other questions. I want to thank both Kelly and Chris for joining us here today. I really think that you gave our attendees a lot to think about, and we are recording this, so I know folks will be interested in listening in when they have an opportunity to do so. So thank you very much, and have a great rest of your week.
Great.